Wills are one of the most important documents a person might sign during their life. In our final report, Modernising Wills Law, we make recommendations for the reform of the law governing wills. Our report includes a draft bill to make it easier for government to implement our work and for practitioners to understand its effect. The law governing wills has not been comprehensively reviewed for almost 200 years. Our project ensures that the law governing wills remains fit for purpose today by making recommendations for a modern law of wills. The project has been guided by three key objectives. We are recommending reforms which support the exercise of testamentary freedom, protect testators, including from undue influence and fraud, and increase clarity and certainty in the law where possible. First, then, is testamentary freedom, the ability of an individual to determine how their estate will be distributed after their death. This is a guiding principle throughout the report. We make several key recommendations which are particularly focused on this aim. A significant recommendation is to give the court the power to dispense with the formality requirements to make a valid will, to be used on a case-by-case basis. This power will allow the court to deem a document or record to be a valid will where the court is satisfied that the document reflects the person's settled testamentary intentions. This will address the strictness of the current law under which non-compliance with the formality rules makes a will invalid, no matter how clear the person's intentions were, without losing the important protections the formality requirements serve. Secondly, we make recommendations to protect testators, bearing in mind the serious problem of financial abuse, particularly of the elderly. For instance, we recommend that the existing rule that a person's will is automatically revoked when they marry or enter a civil partnership is abolished. This rule can be exploited by those who enter a predatory marriage with a vulnerable person, marrying them in order to inherit. Predatory marriage is a form of financial abuse which has devastating consequences for the victims and their families. Thirdly, we have sought to clarify the law where possible. A big part of our work has been to create a draft bill for a new Wills Act, which is intended to replace a current legislation, the Wills Act 1837. As well as enacting our recommendations, the draft bill will be a modern, comprehensive and accessible piece of legislation to govern wills law. We also make recommendations to clarify the law and make it more certain. Significantly, we are recommending that specific provision is made to enable electronic wills to be formally valid, an important update to the law of wills to make it fit for the 21st century. However, we also recommend that electronic wills should have to meet specific requirements to ensure that they are safe and reliable.